Hello everyone, this is Akash Srivastav, your law mentor, and today in law library session, I am here with a very important topic for all those students who are preparing for CLAT examination. So when we talk about CLAT examination, you must have seen that in the passage format, that is from the last 4 years, they are asking question in the passage format, they are giving one of the other judgments. So when we talk about judgments, it can be landmark judgment that can be asked from past all the major judgment that happened in India. Also, it can be any particular current judgment. So what exactly I'm going to discuss? I'm going to discuss 5 most important judgment of 2023 in the part 1, and second part I will be discussing next 5 judgments. This is very important for all those students who are going to appear for the examination on 3rd of December 2023. So the first important judgment of 2023 is Vivek Narayan Sharma versus Union of India. So in this case, what happened? So the demonetization decision that was taken in 2016. It was held by Constitutional Bench of Supreme Court from 4:1 ratio that this decision was totally valid and it was not valid. So the action that government took and the objective that there was nexus between these two things. So it's totally valid. And when we talk about the authority by which government took this decision. So it was permitted according to RBI Act, section 26 of RBI Act. They had full authority to take this particular decision. In this judgment, Supreme Court also said that when we talk about any particular action that government takes, there should be some nexus between the objective that they have and the action they are doing. So it is also known as proportionality test. So this particular judgment passed the proportionality test. And also when we talk about this judgment, it was taken, the action that was taken by the government, it was done after consultation for more than 6 months. So according to Supreme Court of India, the action of demonetization was totally valid in nature. Students, the second important judgment of 2023 is KC Cinema versus State of Jammu and Kashmir. In this case, it was decided that right of cinema theatres to prohibit outside food. So you must have experienced that whenever you enter into cinema hall, they say that you can't take outside food within the premise. So in this judgment, it was decided that the right of cinema owners is totally valid and they can prohibit you from taking any food item inside the food, but there will be few exceptions to it. So the water bottle will be permitted and the baby food will be also permitted. So if there's any particular infant along with you, you can take the food in the appropriate amount within the premise also, but any other food will not be permitted. This was said by the Supreme Court of India. In this judgment, Supreme Court also said that the right to practice your profession and trade is permitted, is a fundamental right that is guaranteed under Article 19, Clause 1, Subclause G. So this action, or if the theatre owners or cinema owners are not allowing you to enter along with your food, that is totally permissible. They can do so. The third important judgment of 2023 is Rangappa Javur versus State of Karnataka. So what exactly happened in this case? So the court said that if there is any particular matrimonial dispute and it is settled, then that will lead to quashing of criminal proceedings also. So if there's any particular dispute between husband and wife, and regarding that dispute or related to that dispute, any particular criminal complaint is also filed by bride or from their family. So if there's a settlement between the family or there's a settlement between both the husband and wife, in that case, that will also lead to the quashing of the criminal proceeding that is filed by either of the parties and that is going on in the court. So the whole objective of passing this judgment is that the court wants that there should be peace and harmony in the society. So if there is any particular criminal proceeding and also there is dispute, family dispute, if the family dispute is resolved outside the court or within the court, then that will lead to the quashing of the criminal proceeding. So students, next important judgment is Pradeep Verma versus State of Haryana. So in this case, what exactly happened? It was discussed the reliability of child witness. So you all know that it becomes very easy to tutor child or manipulate child what exactly they need to say before the court of law. So in this case, it was said by the court that there needs to be a proper preliminary examination of the child and it needs to be assured that whatever question are asked to them, they are able to understand the question and give rational answer. So if they are able to do so, if they are able to understand the crime and also what exactly happened and the consequences of crime, all the questions that are asked to them, then we can rely on child witness. We can't just say that if the person is child, then we can't rely on it. So it was said by the court that if we are only relying on child witness, then there needs to be a proper investigation, proper examination, and if possible, there needs to be some corroborative evidence if we want to rely on child witness. So students, fifth and the last judgment of today's session is Sindhu Janak versus State of Maharashtra. So in this case, what exactly happened? It was said by court that registration of FIR is mandatory in cognizable offence. It is not discretionary. It is not dependent on the police officer that if they want to register they can, otherwise they have an option to not to register. This is not the case. It is mandatory in nature. If there is any particular cognizable offense, then they will have to register FIR. So when we talk about this judgment, you also need to understand what exactly cognizable offenses are, which all are cognizable offense, and which all offenses will be categorized as non-cognizable offense. So students, this was all related to today's session. In today's session, we discussed 5 important judgments, but the bottom line is you don't have to retain the name of the judgment. What exactly you need to do, you need to understand what was said in that judgment. So if the same passage comes in your examination, you don't feel surprised. So you should be accustomed with the terms and the concept. The whole objective of this session is again the same, that I'm not teaching you law, I'm not teaching you something that you have to mug up. You just need to know what exactly happened, what exactly is happening in the legal fraternity. So stay tuned. We will be discussing another 5 important judgments in the second part. Thank you.